Thank you so much, Madam Chair, and all members of the committee today for letting us present these important consumer protection bills one more time. Senate Bills 359 to 364. 359 covers the personal data privacy issues that we discussed last year, and Bills 360 to 364 cover the company data breaches. The data breach bills are exactly as they were passed last term, and the data privacy bill 359 has two small clarifications this year. The first one is a definition of identified or identifiable individual has changed slightly to be consistent with the rest of the language of the bill. And then second change was if a person asks to have their data deleted, one of the rights in this bill, it must actually be deleted. They can't just opt them out and keep their data. They have to actually delete the data. So we made that very specifically clear. If a person asks to have their data removed, it gets removed. So in general, for just a quick recollection, data collection is now one of our biggest global industries, generating hundreds of billions of dollars annually by collecting, selling, and sharing our personal data to make money. 20 other states now have already have personal data protections in place, and it gives people the right and the means to say, no, don't track me. Let me change the data if I want to. Let me see what's there. Let me fix it, or let me delete it. SB 359 does this. We worked with many stakeholders who are impacted by this, many of whom are already doing these functions in other states, as well as with legislators and experts around the country to align the content as much as possible with the rest of the country. Some of that includes specifically, we went through this process and eliminated the private right of action as other states have. We providing consumers the right to opt out of data collection rather than our original place where we required an opt-in. So consumers don't get asked again and again about whether or not they need to be, their data can be tracked, but it gives them an opportunity to easily say no. Opt out. We wanted to make sure that companies don't collect information that is not relevant to what the company specifically needs or needs to keep. And those are the main things that we changed over time, and you might remember that. I just wanted to remind you about those because those are all important things. Secondly, just a quick update or overview on 360 to 364. And this is about added functionality, or a little bit of functionality added to the Michigan Identity Theft Protection Act that we already have. So if you recall, when your credit card is hacked or your social security number is stolen, many of you have already been through this or have friends and family that have been through this. It really does mess up your life trying to put, especially your financial life, back together. But if your social security number is stolen, sold to someone else, and then you need help from Social Security, say you've had a serious injury, your Social Security number is already being used by someone else, and you become a persona non grata. You no longer have access to that, and it's a mess to get fixed. So these bills require an impacted organization to investigate and to provide notification to impacted Michiganders of a breach so they can take action to protect their identity or resolve an issue before it becomes worse. If the breach involves more than 100 people, then the incident needs to be reported to the Attorney General. It does make organizations responsible for their third-party vendors' notification to us and the Attorney General, and holds organizations accountable for protecting consumers' private information, and that does include third-party vendors also. And if enacted, lastly, really, we want to make sure we mention the first and only law in Michigan. This would be the first and only law in Michigan requiring companies to securely store and protect our data. Very important. Thank you for listening. And what I'm going to do before we have questions, if you are already, I want to introduce our expert here who helped us so much through this work, pro bono. Very high-level legal expertise for us, and is generous enough to come with us here again this year. She's a partner at Butzel Long, was a co-chair of the American Bar Association Subcommittee on Data Security. So she is an international expert on this topic, and we're happy she's here today with us. Claudia.
Thank you, Senator Baer, and thank you for this opportunity to speak before you again on this very important potential legislation, Senate Bill 360 and 364. I also have comments on the privacy legislation. Should I start? Which one first? perhaps
Whatever you
going
like.
into the privacy, Senate Bill 359. And yes, I am a shareholder at Butzel. I have a long history with the ABA and working on cybersecurity matters, but I am here today not as a lobbyist, not as a representative of a particular client or anything else, all of whom those voices are important, but here as someone who has lived and breathed this particular area for, gosh, since 1995. And that goes back to my first involvement in the dot-com era in the 90s. And if you recall, at that time, Jennifer Granholm, rather, was the AG in Michigan and brought an action against DoubleClick that was collecting data on people as they were moving across websites. That was a major issue with regard to privacy in those days. And this whole issue that is before us in terms of privacy stems from the EU. And you may say, well, what does the EU have to do with legislation in Michigan? Well, that really was a response in Europe to the 1930s and before, and the Stasi in Germany collecting data on people. That's sort of the origin of these privacy laws that we're looking at today. And so over the last 30 years, I've represented thousands of clients with regard to their privacy and data protection issues. The EU's adoption of the General Data Privacy Regulation, GDPR, and the UK's Privacy Act gave rise to this tremendous upwelling in the EU and across the globe, frankly, for how to protect individual information. How does a consumer, how does an individual have any control over what is really their currency in the market? And others thinking, okay, this is great currency, I'll just take it and use it. There's value here. Anybody who has realized the value of that data knows what the cost of a customer list can be when a company is in bankruptcy and tries to sell its customer list as a tremendous asset. So why am I mentioning the EU and the General Data Protection Regulation? It has various components that you'll find in the 19 or so states that currently have privacy legislation on the books that will be enacted by January of next year. And those are things like you have the right to know who is collecting your data, who's grabbing it out there. What are they doing with it? What purpose do they have for collecting that data? How long will they hold that data? Who is processing the data for them? What company is that? And does that processing company, is that company going to protect your data as well? The other kinds of rights that are associated with GDPR is to correct the data. What data is out there that may not be correct, and that can be used against you? And also, as Senator Barron pointed out, the ability to opt out and to delete your data permanently, not just take you off the marketing list, but to actually delete it so someone else doesn't come along in a data breach and find that data and do something else with it. Let's get rid of it. So the International Association of Privacy Professionals, the IAPP, is tracking 9 states with pending consumer privacy legislation and 9 states where their bills are currently inactive. So you've got about 37, 38 states out there with this either active on the books or active or in a stalemate right now, currently not active, but at least some legislation out there. So Michigan is one of the 13 states without any privacy legislation, and I, as one who has been in this area for decades, would love to see that legislation be real. We are entitled to control who collects, processes, stores, sells, transfers, and deletes our personal data. Personal data is a form of currency in the digital age, and data collectors and brokers take every opportunity to take that currency without our knowledge and to their advantage. So I encourage you to enact this legislation to place control of our personal data in our own hands, to give us the option to choose when and where we are willing to share that data with others, and that choice should not rest in the hands of commercial enterprises. In sum, Michigan consumers deserve the same rights and protections that citizens of 19 other states currently have or will have by January 26. So thank you for that. If you have questions on that, or I can just move right into the privacy.
Yep, go right into the second part, and we'll open it up for any questions.
So, I'm sorry, not privacy, data breach. So that's the Senate Bill 360 to 364. And I have practiced, unfortunately, this is a very difficult area for many, not only the companies, but also the individuals who are impacted by data breaches. I have served on the American Bar Association's Cybersecurity Legal Task Force that Senator Baer mentioned since 2013, and I'm still active on that task force. So over the past 15 years, I have represented hundreds of clients that have experienced data breaches, from small businesses with less than 10 employees to global manufacturing companies with tens of thousands of employees across the globe. I testified here before last year, and in 2018, I represented a Michigan company that experienced a ransomware attack impacting over 1 million individuals over 37 states. 800,000 of them were in Michigan. We sent out letters to every single person. While state data breach laws have been with us since California first enacted its legislation over 20 years ago, it took many years for all 50 states to enact their versions of data breach legislation, and they have not been uniform in their definitions and requirements. In the early days of data breaches, we would identify where individuals lived to determine whether their state had any data breach law in effect at all. As the number of states with data breach legislations grew, notification and compliance with each state's laws became more complicated. We developed spreadsheets for states with basic terms and requirements, which we constantly update. When we represent a client with nationwide offices and employees and customers in multiple states, we must carefully assess what the client's legal obligations are in every impacted state. Some states require notice only to the individuals whose PII was accessed or acquired. Other states require notice to the AG, credit reporting agencies, or the insurance commissioner. Most states want the notice to individuals to provide some details on what happened. Other states don't want that detail. My review of the draft Michigan legislation incorporates the best practices that experienced data breach counsel have urged clients to adopt over the last years. We are late in amending our data breach statute, but we have the opportunity to incorporate these best practices into a bill that really not only helps the individuals whose information is breached, but also the companies who have collected, stored, and used that information to guide them and provide the insight that they need to provide the protection for Michigan citizens. So thank you.